Okay, everybody, we can get started. This is a conversation about antitrust law and how it applies to the AI industry. This is a CLE panel. We have an extended period on the calendar today on the agenda to accommodate the expanded panel that we have. So Alden can take as much time as we have. We can go all the way up to lunch if necessary. So let me introduce our moderator, my good friend, Alden Abbott. Alden is former IP czar at Heritage. He was then the general counsel at the Federal Trade Commission. Earlier in his career, he spent time at the Federal Trade Commission and DOJ. And now he is senior research fellow at the Mercatus Center at George Mason University. And it's been a privilege getting to know Alden, and he is, if you don't know Alden, you need to know Alden. He is, on all things economics, one of the go-to people in the world, and certainly in the DC marketplace, and it's an honor to have you here, Alden. I'll kick it to you so you introduce the panel and introduce the topic, but thank you very much for being here.
Well, thank you, Gene, for the very kind words, and I'd like to thank you and Renee, Quinn, and the entire IPWatchdog staff for their hard work in making the program possible. And also, Gene, thanks for endorsing my idea many months ago of an AI and antitrust panel. So our expert speakers who have a lot of background in government as well as the private sector will give their perspectives on what's happening in AI antitrust space. A lot of attention has been paid recently and announced investigations, news about the use of algorithms potentially to promote collusion and raise prices. I noticed there was some sort of press release by the administration about a new task force on unfairly high prices or price hikes and so forth. And that but it just points out that in inflationary times, even though this may have nothing to do with the causes of raising prices, higher prices and concerns about big business and collusion are very much in the air. And there are also concerns about potential monopolization, that is major platforms using market power through acquisitions or other activities to strengthen their positions. As moderator's prerogative, I will mention the Mercatus Center issued just late last week a primer on AI and antitrust, written by my colleague Satya Marar. It's available online and it's part of the CLE materials, and we're going to update it, as I said. So I'm hoping you find it useful. It's pretty general and also reflects the fact there hasn't been a huge amount of actual antitrust activity specifically directed to alleged harm to competition coming from AI. There are a few cases, I'm sure we'll get into that. Let me introduce our outstanding speakers first. Barry Nigro, partner and chair of the Global Antitrust and Competition Department at Fried Frank, and former principal deputy assistant attorney general for antitrust at the Justice Department, also former deputy director in the Bureau of Competition at the Federal Trade Commission. Aaron Hogue, chief of the Technology and Digital Platforms section of the Antitrust Division. Julie Carlson, director of economic strategy for Qualcomm, who also has a background in academia and spent years as an outstanding FTC economist. And Thomas Hazlett, who's a partner at Ballard Spahr. He's head of the firm's e-discovery and data management group. And he's an up-and-coming star, undoubtedly. Unfortunately, Randy Long, a longtime friend, who's assistant general counsel for antitrust at Microsoft, was called to Washington State this weekend. So he sends his regrets and told me he very much had wanted to be here. So this panel is going to have a free-flowing discussion. And we'll start by directing specific questions to individual panelists, have everybody else join in as appropriate. But before going ahead, let me ask one question. I assume, but I should never assume, as we know, it makes an ass out of you and me, as I was told by an older generation. How do you all feel you have some basic knowledge of antitrust? Is there anyone who doesn't?
Yeah,
Okay,
anybody
one
that's
person.
willing to raise your hand now, tell us that you don't know anything about
You might want to
antitrust.
phrase that.
Well, here's the thing. I mean, if you're exposed, yes, that is rather unfortunate. I don't want to insult the intelligence of anyone. You all here are very, very bright experts, but some people just in their careers have not had to involve themselves, thankfully for them, in the twists and turns of antitrust law. Let me give just a couple of minutes. I think you're generally familiar. The major antitrust laws are the Sherman Antitrust Act, sections 1 and 2. One has to do with contracts, combinations, and conspiracies, unreasonable contracts, combinations, and conspiracies that harm competition. Section 2 is monopolization, maintenance of monopolies, attempted monopolization. The Federal Trade Commission, through Section 5 of the FTC Act, it can't enforce these statutes directly, but indirectly. Violations of the Sherman Act are also violations of Section 5, and the FTC has always argued Section 5 goes well beyond to reach certain things that the Sherman Act could not. For instance, parallel anti-competitive activity not involving an agreement. In principle, you need an agreement for violation of Section 1 of the Sherman Act. You can infer it, but the FTC has always thought it's a broader statute. Also, Section 7 of the Clayton Act, the merger law, which is enforced by both the FTC and the Justice Department Antitrust Division, the two agencies. Each agency tends to bring cases in this area of specialization. There is a clearance process by which decisions are made as to which agency will review a particular merger. And since 1976, mergers, and I won't go into the gory details, mergers above a certain size, it's more complicated than that, have to be notified to the agencies in advance before they're consummated to give them a chance to examine the mergers. And that pattern, that's also a case in Europe. Most countries around the world now also, many of them have pre-merger notification, not all do, however. But right now mergers are looked at by many countries, as are monopolization and anti-competitive agreements. And so that's a quick and dirty on US antitrust. European antitrust is a little trickier because the big difference, I'd say, is Article 102 of the European Constitution, which says that abuses of a dominant position violate the law. Now, abuses of a dominant position are something different than monopolization, because the U.S. law said if you're a monopoly, get monopoly power earnestly, you have a lot of leeway in how you obtain profits in that monopoly. You can't engage in something that distorts competition, harms consumers, but that doesn't mean you have to help your competitors. In fact, competitors, for example, may want access to your platform. Generally speaking, the Supreme Court has said it's almost impossible to require a company to deal with a competitor, or to give them, there's certain rare exceptions, but basically there's a lot of leeway for so-called monopolists. In Europe, you can have a lower market share, say under 40%, and still be viewed as dominant. And the European view is that there's lots of activities that a dominant firm cannot do. Once it's believed to be dominant, that certainly other individual firms could do. To some extent, that's true in the U.S. But the basic message is that historically, in modern times, even though Europeans, as well as American enforcers, have said that they're, at least until recently, that they're interested in promoting consumer welfare, companies have had a tougher slog. I will mention, probably a lot of you have heard about the changes in antitrust the last 3 years under the Biden administration. Some have called it neo-Brandeisian antitrust. Up from, I'd say, from the 90s to about 4 years ago, there was more or less a bipartisan consensus that you look at hard facts in investigations, anti-competitive activity that harms consumer welfare, distorts the competitive process. The current leadership of the FTC and also actually Justice Department says, well, no, antitrust should look at a broader list of concerns. Are workers being harmed, say, by a merger? Will there be fewer unionized workers? Will there be environmental concerns brought about by merger? Will a merger redistribute income? Will poorer communities have fewer services or fewer stores? So there are a number of additional factors that certainly the Federal Trade Commission chair has emphasized should be front and center. And the head of the Antitrust Division, he said fewer things about that, but basically the same message. And also the Europeans have talked a little bit less about consumer welfare than they did in the past. And I think there's the leader of the European Antitrust Agency, the Commissioner Vestager, has said that basically we're close. In fact, she praised the U.S. leadership on more than one occasion, saying finally the U.S. leadership gets it, and we the European enforcers and the American enforcers are coming closer together. The specific sort of neo-Brandeisian concerns about labor and so on, they're not mentioned as publicly or openly in Europe. So what does this mean? I think we don't know. As I think you'll hear today, there has not been a lot of more actual enforcement, actual cases. A Federal Trade Commission seems interested in passing regulations. Whether it has authority to do that remains to be seen. But things are somewhat in a state of flux. And I think, at least for now, my personal view here is that the law, federal antitrust law, makes it not tough, I think, to consider additional factors. 1979, U.S. Supreme Court said that consumer welfare was basically key, that antitrust was a consumer welfare prescription. So how the courts would react to antitrust litigation where charges and complaints went well beyond sort of traditional concerns about harm to the competitive process and to consumers is to be seen. So there's lots of uncertainty, lots of stuff to unpack. I'll quit, but I should also mention this is not the only problem in Europe. Europe has passed something called the Digital Markets Act, which requires 5 major U.S. platforms and 1 Chinese platform to interoperate with third parties, not to favor their own enterprises, and so forth. And that is aside a new law, the artificial intelligence law, which is just coming in this year, it was being finalized. But the antitrust leadership in Europe has said these laws are all going to be in parallel. You'll be subject to antitrust enforcement. You'll be subject to the regulations under this new Digital Markets Act, detailed regulations still being worked out, and you'll be subject potentially to penalties and regulation under this Artificial Intelligence Act is a bit different. It says what are the risks? There are different risk categories of behavior in artificial intelligence space. Some that produce almost no risk. So we'll calibrate the amount of regulation to the degree of risk. Just as the Digital Markets Act seems to be, at least for the moment, only focused on big platforms, certainly Microsoft, Apple, Google, Facebook, Amazon, and ByteDance, which is the parent of TikTok. It's the only non-US platform. Let me quit right now. I probably said more than necessary, but just to give you a flavor that there's a lot going on, but a lot of uncertainty. So let's get started. Barry, there's a lot of concern about competitors using AI, and in particular, AI-based algorithms to facilitate price fixing and other forms of anti-competitive collusion. So our case is being brought, investigations being conducted, And what do you think in-house and outside counsel should focus on in assisting their clients to avoid problems? I'd also like to ask Thomas about a recent matter, this whole RealPage case, which bears on this topic.
Yeah, so thank you, Alden. Thank you, IPWatchdog, for hosting this important conference. There are lots of cases being brought. I think there's some investigations that Aaron will say he can't talk about, but I've seen reference to them in the news, and a lot going on in the space. There's certainly a lot of issues to deal with. There haven't been, notwithstanding all the cases, I don't believe there have been any enforcement actions directly involving AI. Aaron can correct me if I'm wrong, and Aaron's the person I relied on when I was at the Department of Justice for all this stuff, so he knows what he's talking about when it comes to this topic. The way I think about AI, before I get to the specific question, is it's just a tool, like many that we've used in our day-to-day business. It just happens to do things better and faster in some respects, including with respect to pricing. I experienced that this morning with the dynamic pricing on the Beltway. I think for one segment it was $40, and the only thing that surprised me more than the price was how many other people were driving in the Easy Pass lane paying $40. I was actually quite surprised. It was there was still a lot of traffic. They probably could have charged $60. But it does provide benefits that humans and other technologies can't, by balancing out supply and demand, for example, with dynamic pricing and other things. But there are ways in which it can create antitrust risk and potentially run afoul of the antitrust laws. And I think Thomas is going to talk about some of the civil litigation that's going on. There's a bunch of it involving RealPage, involving resort hotels in Las Vegas. There's some involving luxury hotels. The cases are all a little bit different in terms of the allegations, and I think we'll get into that when Thomas digs in. But just thinking about this at a high level, the basic issue is whether the algorithm is being used to facilitate an agreement in violation of Section 1, as Alden described. And there are two types of agreements. There are express agreements. You can call them handshake agreements, or where there's an actual meeting of the minds. And those are the easy cases. And I would be surprised if anybody was using AI in that way, because it's an obvious issue. The more interesting and subtle question is whether AI and algorithms are being used to facilitate tacit agreements. And Alden indicated that agreements can be inferred from circumstantial evidence. So there's that issue, but then there's also this thing called tacit agreement, where it's essentially coordination without an actual agreement. And there's concerns by enforcement officials that AI is contributing to the risk of tacit coordination, tacit agreement, and that's resulting in higher prices and tempering competition. So I guess probably the issue that's trickiest, especially if you're in-house, is dealing with the situation where you can infer an agreement based on AI, and this is where some of the details of these cases that Thomas is going to talk about become important, because it's not just the use of an algorithm by itself. There's nothing unlawful about that. I mean, as I said, there are a lot of benefits that you can derive by using AI or algorithms or other tools of that sort. It's really sort of some of the things that surround it, and so a lot. You can ask the who, what, where, why, how questions, And the, one of the things that I think is apparent when you read or listen to what the FTC and the DOJ are saying, and when you look at these cases that have been filed in the civil cases, the class actions, it could depend on whether the information that's being fed into the algorithm is public information or confidential non-public information. It also could depend on whether the confidential non-public information is competitively sensitive or not. Is it the type of information that might affect behavior? It could depend on whether the algorithm's making a pricing recommendation or not. Is the algorithm, spitting out a specific recommendation, and are people following it? And there are questions about, and these are all things you should, if you're using AI or marketing people are using AI, these are questions you should be asking and making sure you understand. I mean, if it spits out a recommendation, is it one that's typically followed? Does the company that sponsors the software, do they have enforcement mechanisms in place, or does there tend to be adherence for other reasons, peer pressure, or whatever? Is the algorithm being used widely in the I'll use an antitrust term, relevant market, or is it just one user in the market, in which case it may not be facilitating any coordination whatsoever. So you need to think about how this algorithm works. What are the inputs? What are people's reasons for using it? Is it to be able to align with their competitors, or are there other benefits that are perfectly lawful and legitimate? Another thing to consider, just in evaluating sort of the context in which all of this is happening, is it a noisy industry? And by that I mean, is it one where, in addition to the use of the algorithm, there's a lot of talk among competitors about, if you focus on the cases that Thomas will talk about, occupancy rates. That's something that, I can go to all kinds of websites, apartments.com, and figure out what the prices are for a 2-bedroom apartment in a particular area. I don't see anything wrong with that. If I'm in the business, my competitors can do the same thing. So there's nothing wrong with that, and there's some efficiencies associated with that. But if the algorithm's sharing, in addition to that information, non-public, competitively sensitive information like occupancy data, then the question becomes more complicated and raises a whole new set of issues that need to be evaluated in order to assess what the actual effect on competition is. So there's lots going on. There haven't been any actual enforcement actions, lots of private litigation, and my advice is just to make sure that you understand how the algorithm's being used, how it works, who, what, why, where, when, how, all of those things before signing off on it, because the marketing people will find this stuff to be very useful and be happy to use it. But it's your job as in-house lawyers or outside lawyers to make sure you flag antitrust risk where it exists.
Yeah, so as Barry mentioned, in the sort of lack of direct government enforcement actions, our more entrepreneurial colleagues in the plaintiffs' bar have stepped into the breach. For some reason, they've decided that the real estate market is a fruitful one. So there's a multi-district litigation that is currently being handled in the Middle District of Tennessee involving a software company called RealPage. There's been cases regarding hotel casino offerings in Nevada, a similar case brought in New Jersey. All of these cases are in their early days. Motion practice is happening. The record hasn't been developed yet, but the plaintiffs' bar has had some success. In the Middle District of Tennessee case involving RealPage, there were 2 classes that were pursuing claims. One based on a class of multifamily rental plaintiffs and one on a class of student housing, not through a university, but apartments near a campus. The multi-family rental plaintiffs, one got past the motion to dismiss. The student housing plaintiffs did not, but at least as things currently stand in that Tennessee case involving RealPage, the multi-family rental unit plaintiffs are going to be able to move forward and start discovery. There was a couple interesting things out of the judge's decision in the RealPage case. One is for these Section 1 conspiracy collusion claims, you have to show an agreement, you have to show harm to anti-competitive conduct as a result of the agreement. You have to show that it impacts interstate commerce, which isn't really an issue, and then you have to show antitrust injury. The court found that both sets of plaintiffs had established, had pled sufficient facts to show that there was an agreement in place, not the sort of smoke-filled room explicit agreement, but the tacit agreement that Barry talked about. The court found that based on a change in the pricing model for the participants, for the companies that were using the pricing software that happened after they agreed to use it, and some other factors that there was at least a sufficient pleading at the initial complaint stage to show that there was anti-competitive conduct happening, harm to competition happening. And then the injury in terms of inflated prices, super competitive pricing was the kind of injury. There were also some interesting quotes that I think are useful to think about in terms of what in-house counsel and outside counsel advising companies that are using AI. Former FTC Commissioner Olhausen submitted a declaration. It had kind of a pithy quote that the court used, which is, if you're talking about using an algorithm to engage in some conduct and you're trying to figure out whether there's antitrust liability, substitute the word algorithm for a guy named Bob. And if a guy named Bob doing something is going to create antitrust liability, then the algorithm is probably doing the same thing. So it's colorful and it kind of sticks with you, so it's something to think about. But I think that brings up a wider issue that has been touched on, has been a theme through several of the panels yesterday and today, and on what Barry said, which is that AI is the next great mousetrap and the next great tool, but antitrust law has issues, has doctrines and has precedent that addresses a lot of the legal issues. It still fits nicely within the conceptual framework. So this idea of, people talk about a hub and spoke model conspiracy, where you have a central actor that serves as a clearinghouse for potentially competitively sensitive information, or an enforcer or a coordinator, and then the participants around the hub of the hub and spoke are all at the same level, all participating through the hub and all engaged in parallel anti-competitive conduct. So if you have an algorithm, dynamic pricing software that acts as that hub, and you have market participants like various landlords or various hotels or what have you, those kinds of cases have happened lots of times before. There were wood and paper product cases involving mill data that was reported out, that the reporting of the mill data was the mechanism by which the conduct was coordinated. There are currently cases going on involving, people talk about protein cases, it's chicken, it's pork, it's meat products, where this little company called AgriStats that takes in data, supposedly anonymizes it, and then sends out reports to participants these AgriStats reports are allegedly the mechanism by which the protein producers, the meat producers, are coordinating anti-competitive conduct. All of the things, at least on the dynamic pricing end of things, dynamic using software to manage capacity and occupancy, all of those things are fit nicely into kind of existing rubrics and as existing ways of analyzing conduct. I think the more interesting question, and I think the thing that all of us are wrestling with is, in terms of generative AI or general artificial intelligence, it might not be as clear and might not be as easy how those fit into existing approaches to antitrust issues.
Good.
Can I make a comment? Because Thomas mentioned the AgriStats case, which is a case about AgriStats was a third party that just sort of aggregated data with respect to some of the proteins, and then it would be used by competitors to set prices. It's really, those sorts of things are just as interesting as AI in some respects, and making sure that you understand sort of the inputs and the outputs and who's participating, how it's being used. All the same questions you would ask with AI, you would ask with that stuff. And what I've learned since leaving the government and going back into private practices, there are lots of companies out there that use these third-party reporting services, and they use them because they've always used them. And then when you start asking questions about the details, like how is the information collected, how is it reported back out, who's getting it, how's it used, you sometimes realize that the way that the product is being used raises issues, and people just assume because it's been used for years or decades even that it's okay, and it's not necessarily okay. So AI is just sort of a modern version of that in some respects. There are other attributes of AI that raise different risk, but I think it's just important to sort of focus on the old school AI, if you will, as the new AI.
Yeah, I think Barry made a very good point. In fact, there's Supreme Court precedents that are from the first half of the 20th century that deal with hub and spoke conspiracies, and that's always been information exchanges, risks, use of trade association. Those have always been very important and crucial counseling issues for antitrust advisors. So nothing's new.
Yeah, and one more, and this is a little bit of a detailed issue in terms of the antitrust legal issues, but there's one other important point in terms of the risk profile to companies using AI, which is that at least this one judge in the Middle District of Tennessee said that this sort of business model is, in their mind, at least new enough that they were not prepared to find that the per se liability way of analyzing antitrust claims would apply, and instead was applying the rule of reason test, which is much more of a balancing test. Per se is no bueno for those that are alleged to be violating it. Rule of reason, there's a lot more. There are a lot more issues to raise and defenses to raise and things to fight about. And so I think in terms of, again, how to advise on risk, that was an important distinction that the court made. One district court in Tennessee, although it's a case that a lot of people are focused on.
Can I make one additional comment, Alvin?
Sure.
First, I should say that all my comments here are my own personal views and shouldn't be taken as the official view of the Department of Justice. And as Barry says, I won't be commenting on the facts of particular cases or things we might or might not be investigating. But I will note that one case that was brought in the algorithmic pricing side was a criminal case that was brought because it was one of those sort of kinds of cases that Barry was talking about that are the easy ones, right? Two people get together and they decide they're going to use the same pricing algorithm in order to price their, I think it was like posters sold on Amazon or something like that. Like that's classic price fixing. The fact that an algorithm is used to implement it doesn't really change the legal analysis at all. That's how you end up in jail. So that's first very easy. Those are the easy ones to advise on. Also note that on the RealPage case, the Department of Justice did file a very extensive statement of interest, sort of setting forth our thoughts and analyses of the question of, when can you infer an agreement? What's a tacit agreement? What's an explicit agreement? What are the plus factors that are relevant? How many do you need plus factors? And so it's gets very into the antitrust weeds, but if you're interested, it's also one of the CLE materials for this class.
It also, I think, reflects some pretty aggressive positions, if I say so myself.
I think we would take that as a compliment rather than a criticism. So, yeah.
So Aaron, thanks. Of course, you oversee a lot of work on digital platforms, and as you said, you can't comment on specific facts or matters that might be under investigation. But just to mention that there are arguments out there about the efficiencies that AI can bring and scale efficiencies of having platforms use AI. For instance, AI services or features are always continuously being developed for consumers and adjacent businesses by platform providers. AI is also built into improving the efficiency of platform operations, and cloud producers and cloud providers, offer an array of AI services to businesses to enhance their productivity. So anyway, there's these efficiency stories when you're not dealing with talking about per se rules, rule of reason. You have to plead, put credible story about harm to competition, but you can respond about, there are certain efficiencies. So Aaron, how do antitrust enforcers, and particularly you as a platform overseer, so to speak, weigh these benefits? What are enforcers' major concerns about platforms' development and deployment of big AI? And again, big picture, what should legal advisors to platforms and other large businesses be concerned about in advising their clients, knowing that DOJ is closely monitoring their activities?
So first you have the whole set of conduct issues that we've just been talking about, which are the use of sort of algorithmic pricing. I'll just kind of set that aside because we've been talking about that for a little bit. The other issue that I think that we're sort of definitely have our eyes open on is the development of AI as a tool and used in other markets, and what effect is it going to have on competition in other markets. And I think, as with many aspects of AI, whether that's ultimately good for competition or reinforces dominant positions is a very, very open question that we don't know the answer to, in the same way we don't know the answer of whether is AI accomplishing something good for society or something not, which is not my question to answer, but is certainly an open one. And so, as we look at it, I think it's very much like all these, we've had waves of technological change over the years, and this is another one. And I think it's going to be a really open question and something to keep an eye on as to whether, is AI being deployed in a way that it actually is restraining competition, or does it enable competition? And so, you think about, back to the last wave of like cloud computing. I think that while, people may have particular issues with particular pieces of conduct, like as a general matter, enabled a lot of companies to enter markets, offer services, services that were competitive against incumbents much more cheaply than they ever would have been able to before, because they had this, amazing, sort of expandable at will technology and infrastructure to be able to use. And so the question with AI is it going to follow that model, or is it going to follow a different model? And I think one of the real challenges with the AI is that it's, as we've seen, it's incredibly expensive to train, it's incredibly expensive to deploy, and that has forced, even though there are a lot of companies that are smaller companies, that are new companies to the industry, that kind of pushes them into a model where they have to partner up with the existing companies in the industry. And so one thing certainly to keep an eye for, and again, I'm not making any comments about any particular practice of any company. If Randy was here, I wouldn't be specifically commenting about what Microsoft's doing, for example. But even when it's not here, I still won't comment on it. Maybe it is why he's not here. Great point. But the question is whether these tools are being that creates a real risk that the tools end up being used by the companies who already have power in adjacent industries, or whether they're sort of widely available. And so that's why I think it's very important to think about, if you're a company that's involved in any aspect of this, are you engaged in an agreement? Have you signed up to use AI? If you develop AI, is it being deployed in such a way that it's being sort of limited and restricted to supporting the position of a certain, of incumbents in the industry or not? And I think, that's going to be something that we're going to be keeping a close eye on. Maybe I offer sort of one specific case I can talk about, since it's already in litigation, is a little bit of a testing ground for that. We've had our Google litigation that's been going on for some time in the search markets, and trial was finished in the fall, and we have closing arguments in May. And certainly one of the issues there was, well, AI is coming, so what does that mean? And I think as with so many of these developments, I think what it doesn't mean is that therefore there's no reason to be concerned about anti-competitive behavior anymore. Some lawyers, not good lawyers like Barry, but some antitrust lawyers will come in and say, well, you have AI, so there's no reason to be worried about anything. That'll certainly defeat every bring technological revolution to the industry, and there's no reason to be concerned about anti-competitive behavior. But I think what we see in that case is a little bit of the opposite, really, that if you think that to the extent that generative AI is going to be important for the development of search, which is something that we don't know, but it could be, to the extent it is important, it's really important that the dominant player in the industry not have contracts and restraints on the markets that prevent its competitors from being able to get to market. And so, I think of it as maybe even more important to have those kinds of enforcement activities like we had in Google search, if there's a real opportunity for AI to be, really shake up competition, because without that, we'll never be able to take advantage of that opportunity in the market.
Barry, Julie,
Well,
any thoughts?
I guess one thought is, it seems to me that notwithstanding the concerns about existing players using AI to their advantage, let's say, you would expect that companies in adjacent markets would derive more efficiency and be interested in making a bigger investment in AI than companies in non-adjacent markets. And so, how, and I've heard the AAG, Jonathan Cantor, talk a lot about concern over locking up key inputs, crucial inputs, and those sorts of things, because you want to have a competitive market. You don't want, especially in the early stages of the market, you don't want somebody to lock it up, so to speak, or foreclose competition. So how do you sort of balance those efficiencies that an adjacent player might derive against some of the concerns that have been articulated by the department?
Yeah, I think one important fact is to look to what the actual terms of any specific situation are, and ensure that there aren't restraints that are sort of embedded in the arrangement that are more stringent than are necessary to gain those benefits. And so I think that's a really important part of the analysis, because it's if you don't have a kind of least restrictive alternative or less restrictive alternative or some version of that framework in your head, you can, I think, get to the sort of position too far in the other direction, where it's important that AI be developed. This seems to be the way that it's being developed, and these are the resources that are needed, and therefore sort of that's good, and so we should allow that to happen in whatever form it is. And I think that's not the right frame of mind to think about it. I think it's looking at what the actual terms of an investment, of an agreement, of a restraint are, whether there are any that are distorting competition in ways that really aren't necessary to actually achieve those benefits of scale, the benefits of investment, and the benefits in complementary markets. So I think that's one thing that I like to think of first.
Before turning to Julie, it raises an interesting point, because there's this, antitrust traditionally teaches purely unilateral behavior very differently than joint behavior. For instance, in unilateral behavior, generally, a large firm, including a monopolist, has a certain amount of leeway. As I say, it is not required under the law usually to use the least restrictive means to achieving an efficiency. It's given, I would argue, a certain amount of leeway. There's some debate about that, but that's something to keep in mind. And it'll be interesting to keep in mind to see how the courts deal with this issue. Regarding efficiencies, Julie, as an economist, what do you have to say?
First of all, say thank you, Alden and Jean, for having me here on this panel. This has been really interesting. So I agree a lot, actually, with what Aaron said, which I was surprised by. I didn't think I would as I sat down here in
He's
my
a reasonable
seat today.
It's undoubtedly your FTC experience that's kicking through here.
I guess I would just start by saying that, we are and should be, right, really excited about the potential for AI to improve productivity and to make firms more efficient. We've seen just in the last couple years, right, these really breakthrough innovations entering the marketplace. As the lone, corporate representative here, I guess I'll sort of toe the Qualcomm party line and promote that we just announced this fall on-device generative AI in a way that's supposed to enhance privacy and security. And so all that's to say is a lot is happening very quickly, right? And we don't know, and I think Aaron raised a lot of this, we really don't know at this point what a lot of the uses for AI are going to be. And so I think it's a little premature. So I'm going to dodge your question a little bit, Alden. I think it's a little premature to think about how to weigh efficient uses of AI against sort of anti-competitive uses of AI for a lot of the reasons that Aaron already mentioned. And I think, as Aaron suggested, right, antitrust enforcers should be working kind of closely with industry to understand how these AI tools are evolving. Before, right, really, intervening in markets. So I think the example that Aaron gave of cloud computing is a really great one for where, sort of letting that space evolve, and that's turned out to be really pro-competitive. And we've talked a little bit about sort of digital platforms. Something else that I hear in this space about AI, that there's this concern that large digital platforms could use AI tools like digital assistants, for example, which are really AI driven, to further lock in users. And again, I just think it's really too early to know if there's going to be these interoperability concerns around these AI tools. So again, need to proceed in a fact-based way, as very much as I think Aaron has suggested that the Justice Department intends to do, and not assume that sort of regulatory intervention, whether that be antitrust, whether that be ex-ante regulation, is really the right way to go. And it may be the case that regulation is the right thing to do. I think it's just too early to know that in this stage of the industry's development, despite the hubris of the European Commission. And I think why I'm sort of striking a cautionary note here is that regulation could also have the unintended consequences of kind of maintaining incumbency advantages, right? Where you get some sort of regulatory capture with the incumbent firms. And so I think just being really cautious, having antitrust enforcers work with industry, and really proceed in a fact-based way is the right path forward here. So maybe not answering your specific question, but
Thomas?
Can I, just piggybacking off of what Julie said, and also picking up a point that Barry made, he did the air quotes about relevant market, and that's a really key issue for antitrust law specifically. And for a lot of the chatbots, I think the two markets that I've picked out so far are technology reporters writing articles about, look at this chatbot telling me I should divorce my spouse, and then juniors in high school trying to cheat on their college entrance exams. I'm not quite sure that we know what the market is. Julie made the point that it's not clear what the use cases are. I think that that's completely right. And when there's such uncertainty about what the relevant market is or will be, there's a real question about when does antitrust law get triggered. If you wait for technology that is so broadly applicable, but you don't know today what that killer use case is, the law really might not apply under current doctrine. And that, to me, is the uncertainty that I talked about before, is how long should antitrust law wait before it intervenes? And there's academics that are, this guy Dan Crane, who is working on a paper I saw presented at Penn a couple weeks ago, and he talks about that when there's such uncertainty about the use case that should, not does, but should antitrust law apply even before the relevant markets are defined? And do you get back to more capacity considerations? And maybe Alden's made the point that a dominant player can't exclude or gets the choice to not work with others. If someone develops a piece of software that is really, really good and really presents the risk of a dominant position for whatever, do you get back to those outer limits of the application of antitrust law? And I don't know what the right answer is, but it's an interesting question that everyone should think about.
This whole issue of access is very interesting. There was an old Supreme Court case called Ottertail, which at the time was read by me as saying that this had to do with wheeling, getting access to an electrical grid. But the point was that, yes, we have what seemed to be a quote-unquote essential facility, something that other parties needed to be able to effectively compete, and there was no easy substitute and reasonable substitute to be produced in the foreseeable future. You had to give third parties should have access to that facility managed by a company under reasonable terms. Many years later, in a Verizon v. Trinco case, the Supreme Court seemed, according to some commentators, to shed a lot of cold water on the whole idea of essential facilities. But that's something that is very much in flux, and it raises, and certainly it's a major, and Europeans are very, very concerned. They don't have compunctions they think that we have. Some would say currently about essential facilities. They're much more ready to find something is an essential facility. And just to add one tiny point, Julie made, I think, the excellent point that you need to be careful about regulation. Now, that's something Europeans are up to right now. We're not ex ante, but one example is GDPR, the privacy regulation the Europeans promulgated, which limited the use of data and very complicated legal requirements that companies, platforms, or companies that had databases had to follow. Well, lo and behold, some people at times said this is going to limit Google and other and its market power. Google's market share increased, and a number of studies suggested it has more market power than ever. Why? Because it had all these lawyers and experts who could. They already had some cost. It had the space of people that could much more easily comply. And these new platforms that supposedly were going to compete with Google, just on the margin, they said it's too costly. We're not going to invest this amount. So we're not at regulation in the U.S., but I think it's a very important point to keep in mind.
Can I make one observation,
yes, Aaron?
Alden? I think that these questions about sort of what are the outer reaches on the enforcement side, to me, they also really put a premium on merger enforcement, which is designed to block transactions that have a risk of competitive harm and not just ones where there's certainty. And so sometimes, one way you can ensure that the market ends up in a more competitive balance is to ensure that there aren't acquisitions that go through that are, have the risk of reinforcing dominant positions. And I think the standard there is properly quite different and properly more open to the idea that you don't have to have that level of certainty, and that it's not a question of, are you telling a firm that they must work with their competitor, but are you allowing them to buy someone who might develop into their competitor? And those are very different questions under the antitrust laws, and I think ones that really, these developing areas really, put a premium on that merger enforcement avenue.
Well, that's very helpful, Aaron. Certainly mergers are very much in the news now, not because there are lots of ongoing challenges, but because of new merger guidelines issued by the Federal Trade Commission and Justice Department, issued in final form in December. Barry, M&A counseling is undoubtedly a tricky business currently. It's what with the new guidelines, concerns about so-called killer acquisitions in the tech arena, which certainly rose at, in the Facebook case. It was alleged that there had been killer acquisitions potentially made years ago by Facebook, among other things. So what AI-specific questions arise in antitrust advice for business clients contemplating mergers? What are your thoughts?
So you're right, the agencies have put out new merger guidelines. They are an articulation of enforcement policy. They're not the law. The law's decided by the courts. But the agencies are using the guidelines in their litigation in an effort to get the courts to adopt some of the principles that are in there, and you're starting to see that come up in cases that are being litigated now. I think in the FTC's case against IQVIA, there was a reference to the guidelines and the 30% threshold. And so my expectation is over the course of the next year, there'll be a lot of the merger litigation will be aimed at trying to promote the new guidelines and advocate the courts to adopt them so that they can become enshrined in law. The prior guidelines and these new guidelines differ pretty significantly from the prior guidelines. Have over time been embraced by the courts, so getting the courts to move away from that is not automatic. There are some areas where there could be some tension between existing law, which may reflect or be consistent with the prior guidelines and the new guidelines. In the new guidelines, there's some discussion about the use of algorithms and other things, and one of the concerns expressed from an enforcement perspective is that AI can make things better known or more observable in the market, and that, if you think about the RealPage case as an example, the concern is that to the extent competitors have a better understanding of what their competition is doing, they may be more comfortable. Let's say this a little backwards. They might be more comfortable not reducing price, because a lot of and Aaron can talk about this because the department's not been shy about making this clear, but some of the concern around AI has to do with its tendency in some cases, and like I said, the facts really matter, to eliminate some of the uncertainty that exists in the market, and competition thrives on uncertainty. And so I think the words used in the RealPage statement of interest were, eliminating independent centers of decision making and things like that. So this the notion that AI will make things more observable, if you think about that in the broad sense, is one area of concern that is specifically addressed in the guidelines. Another one is that it could increase the likelihood that firms won't discount, because if they recognize that as soon as they discount, the algorithm's going to see that and it's going to be matched instantly, so there'll be no temporal advantage. They might say, well, it's not worth the trouble because I'm not going to gain any advantage, so I'll just stay where I am. I don't know that I'm persuaded by that, because I understand the logic of it, but a human being could do the same thing. I mean, gas stations do it when they're on the corner and they post their prices, right? You can see the price just changed across the street, and you could change it instantly if you want. So I don't know that that's necessarily a bad thing, and sometimes it could actually promote competition, because if somebody lowers their price and the other guy lowers the price, the consumer's better off the last time I checked. So I don't think that's such a bad thing. But you do have to think about what do the guidelines, the merger guidelines, say about AI, and because that's clearly going to be an issue. And I'm sure that as mergers roll in that implicate AI, that Aaron and his shop they'll be asking these questions. But then you also have to think about what does the law say, and then that's where you have to make judgments as to how much risk there actually is. And there's risk of getting sued, there's risk of losing, there's risk of getting investigated. There are all kinds of risks, and so that becomes a business judgment in the end as to how much risk you're willing to assume. But it's important as counselors, both in-house and outside lawyers, to identify and all those risks and quantify them in some way, so that the business people can make judgments as to what's worth pursuing and what's not worth pursuing.
Before moving on, I'll just add a point on the merger guidelines. This is not AI, but in a recent administrative complaint challenging the Kroger's Albertsons supermarket merger, the FTC very prominently cited to new concentration guidelines. How concentrated is a market? There's some debate about what is a relevant market I won't get into, but clearly they're referring to standards that are would justify bringing a lot more cases under presumptions of anti-competitive increase in concentration than would typically have been the case in the past. And again, there are more cases out there than they can bring, but clearly the point that the new guidelines are a real difference. In the past, guidelines became more economically sophisticated, less focus on just how concentrated a market is and more on other economic factors. Now there seems to be certainly reference to economic factors, but also big focus on concentration, which worries some commentators. Julie, Thomas, anything to add on this?
I mean, maybe just to Barry's skepticism about the algorithms disincentivizing price decreases, I'll just put on my economist hat for a minute to say, lots of goods are differentiated. So even in the gas station example, right? The gas station that's on the corner right by my house, I'm probably willing to pay more for gas at that gas station than the one that's a block away from my house. And so I think that sort of cuts against the idea that firms would be disincentivized to reduce prices in the presence of the algorithm. So not really on the merger point, but just to support Barry's skepticism.
I have a question for Aaron, though, because I don't think there have been any merger challenges that are directly focused on AI per se. So my question is, how are AI related issues coming up a lot in your merger investigations? A little bit, a lot. You're in the tech section, so yeah. I would think.
I mean, I think they come up a little bit. Sometimes they come up more in the sort of argument about that I was referring to earlier, about how AI is changing the markets. Like, you don't need to be worried about this. This looks like it might, I can see why you might think it's going to be anti-competitive, but in fact, AI is going to enable this company to come in and this company to come in and that company to come in. So I feel like we've seen it more in that context than we have yet to date seen it as, AI is a sort of really a critical input into products that exist today, and therefore the question of access to the tools, or that the merger relates to the actual tools themselves or the infrastructure that's needed for them. I don't think that's something that we have yet seen a lot of, though certainly keeping our eyes open.
Right. So, did you have, Julie, Thomas, anything else on that? No, okay. So,